Hello, everybody, and welcome to Law at the Library, a partnership between the Chicago Bar Association, the Evanston Public Library, and the Chicago Public Library. My name is Lorena Neal. My pronouns are she, her, and I'm the legal literacy librarian at the Evanston Public Library. We're delighted to have everyone here tonight for this presentation on disability law, Medicare, Medicaid, and Social Security. I'm going to tell you a little bit about the format for this evening, and then we will get started. I will introduce our speakers, who will then give the presentation, followed by a question and answer period. If you have any questions for our speakers, please type them into the Q&A window, which you will find near the bottom of your screen. And you can also use the chat feature to ask your questions if you prefer. I will collect the questions as they come up and give our presenters the opportunity to answer them at the end. So feel free to add your questions whenever you think of them. If you have any technical issues or questions, you can feel free to direct those to me in the chat as well. Our next Law at the Library session will be on November 20th, and the topic will be changes to tax law, know before you file. And I'll put the link to register to that in the chat in case you're interested. And in the meantime, you can always see videos of previous presentations of Law at the Library on the Evanston Public Library YouTube page. I'll post a link to our playlist in the chat as well in case you're interested in that. We do also at the Evanston Public Library have a list of general free and low-cost legal resources on our website, so I'll add those links to the chat. Our speakers tonight are Paige Fox of Fox Elder Law and Mark Rafeman of Jeffrey A. Rabin and Associates in Chicago. Paige Fox assists clients of all ages with estate planning, special needs planning, asset preservation and Medicaid planning, trust administration, probate estates, negotiations with long-term care facilities, contract review, and overall assistance with navigating the challenges seniors and individuals with disabilities navigate on a daily basis. She's president of the Illinois chapter of the National Academy of Elder Law Attorneys, or NALA, chair for the CBA Young Lawyers section serving our Seniors Committee, and co-chair of Illinois NALA's Education Committee. Mark Rafeman is a graduate of Loyola University Law School and is currently an associate attorney at Jeffrey A. Rabin and Associates, a law firm focused on disability rights and representation. He previously served as a supervising attorney for the Health Justice Project at the Beasley Institute for Health Law and Policy and has been a staff attorney for medical legal partnerships at Legal Aid Chicago. Welcome to both of our speakers this evening, and I will turn things over to you.
Thank you. I just wanted to start out by saying that we kind of broke the presentation up into two different categories. Part one, which is what will be covered by Mark, and that's more directed at the Social Security, SSI, SSDI. And then part two will be more of my focus, which is more on Medicaid for long-term care and Medicare and related matters. So go ahead, Mark.
All right. Thank you, Paige, and thank you, Lorena. It's nice to be here with everyone tonight. And, I definitely encourage folks to raise questions. There's a lot I'll try to cover and a lot we won't cover because Social Security is an incredibly complicated program, speaking specifically about disability benefits, although we can also talk about retirement and some of the other lesser known auxiliary benefits that people can access. In at Rabin and Associates, the work that we do is to try to help people get approved for disability, but also inform and educate the community about the range of other benefits that you might be eligible for. You might think of Social Security as being upstream of other benefits. And what I mean by that is if you are applying for disability and get approved, it not only will activate some of the income you can receive through disability, but it changes the way you're eligible for other programs like Medicare, certain types of Medicaid, certain types of cash benefits that you otherwise wouldn't be able to access. So in a lot of ways, unlocking that door can open up a lot of other doors for people who are in need of income and just basic support, either temporarily or permanently while they're out of work. So we begin with the concept of what it means to be totally disabled under Social Security. Again, I'm going to be talking mostly about Social Security disability, which itself is broken down into two programs. And when you think about the difficult transition that it can be going from either a state of working or just a state of health to where you really can't go back to work or you're very sick, a lot of people come to Social Security as their first stop. The program is actually designed as really with the highest threshold of standard in terms of being able to access it. And what I mean by that is it's much simpler to access a benefit like unemployment insurance after you stop working, or short-term disability, which is to some extent an employer benefit, or in some cases workers' compensations. To be disabled under Social Security rules, you have to be unable to perform what's called substantial gainful activity, which means that at a minimum for 12 months or for a period expected to last for 12 months, you cannot work beyond a minimal level, which the government generally classifies as about $1,550 per month. So if you work more than that, you are almost always, by definition, not disabled. Can we go back one slide? I just wanted to go through a couple of other things. Thanks. The process looks at diagnoses, which the legalese of that are medically determinable impairments, and there are generally two ways to get approved. If you're the more difficult way, if your condition, physical or mental health, is so severe that it matches a very high standard written into the law, then you can win on that basis. So, like for example, if you have severe asthma and you have a certain measurable oxygen level, and you've been to the emergency room, for example, for enough times as is required by the law, then you can just outright win your case. More often, people have to, will not reach that high standard and then go through what are called functional assessments, where the agency will actually look at, every diagnosis and condition they have, put them together, look at every symptom, or at least they're supposed to, and then compare that to all the requirements of jobs across our economy that are at least theoretically available for people to get. And then it becomes something of a calculation as to how many jobs you can still do based on your conditions. Now, if that sounded simple, which it shouldn't have, because it's not, the actual process of making that assessment on a case-by-case basis is extremely complicated. It involves, looking at a lot of medical records. Part of the reason that you need, or that an attorney can be so helpful in these cases, is that what we do is take, thousands of pages and many times of medical records, function reports, statements from clients, and essentially translate them into functional language to show Social Security which jobs, based with their own complex definitions, a person can and can't do. So that is a little bit, pulling back the curtain on what a very complex approval process looks like. And what we mean when we say at the bottom here, there's a focus on function. Next slide, please. So there are two programs that actually use the same medical review. So when you apply for disability benefits, and people will use that term somewhat loosely, you go through a medical screening process similar to what I just talked about, but you're going to be eligible for one or both of two programs if you are found to be unable to work based on your health. The first one is the bigger one, the more traditionally well-known one, SSDI, or Title II. That is accessible to people who have significant lifetime earnings. The rule of thumb is that it has to be at least half of your adult life you've been working, and working recently before you became ill, injured, and otherwise disabled. And you can get a much higher amount of monthly income in that program. The rules for returning to work and keeping your benefit are more generous. It's an easier program generally to manage because you're collecting funds based on what you've paid in taxes through your lifetime earnings. A second program known as SSI, Supplemental Security Income, again, uses the same health and medical process to determine if you're approved or not. But it's accessible to you if you're not eligible for SSDI, And unfortunately, because it's called a program of last resort, the rules are much stricter. You have to basically have exhausted all of the other benefits that you might be able to get before you can get SSI. And that manifests in practice where people, if they turn 62, they're eligible to take out early retirement with a penalty. But before you get SSI, you have to accept that penalty. So that's one drawback. You cannot save much money if you have $2,000 in the bank as a single adult, or really more than 2,000 of any kind of wealth. They won't pay you for that month. Almost dollar for dollar, your benefit can be reduced based on the amount of money you earn. And even accepting something like shelter for a friend can reduce your benefit by a third. And your benefit starts out at a lower amount, which this year is $942. So in some ways, it's a very harsh program. I mean, there's studies around the country that even the amount that they give at full federal benefit rate isn't really enough to live on in most areas of the country. So it's something that a lot of advocates, both from the nonprofit and private sectors, have been asking the federal government to really make a little bit more generous and a little bit less stingy. There have been some, really promising movements of late with the new commissioner, Martin O'Malley. One being, and if you weren't familiar with the program, you might be amazed that this was even a rule to begin with. But if you were on SSI and someone was regularly, helping you with free groceries, Social Security would actually count that against you in the past. As of 2 weeks ago, that rule has now changed. So they no longer count food against your monthly benefit, which is, a wonderful innovation we've been waiting for a long time. But there's a lot more to do to make this program, a little easier to use. But for the time being, these are the two programs that you can get as far as disability benefits go. And both are also accessible if you're not disabled once you hit 65, or really in some cases 62. You can get SSI at 65 or older. You can get the equivalent of SSDI, which is retirement benefit, at 62. But again, if you take it, anywhere between 62 and 70, the younger you take it, the more the penalty you suffer is as far as ongoing payments for the rest of your life. So getting back to the analysis for adult claims, and I should call out adult here just to mention that there's also child claims. It's a similar but distinct process for children who have limitations. So for tonight, we're just going to focus on adults. They ask, a number of questions. Really involved in SGA should probably be front and center here, because if you are earning more than that 1550 level that I mentioned before, you're almost categorically not going to be eligible for Social Security disability. They will ask if you have a severe impairment, which again is a diagnosis that has symptoms that are interfering with your basic activities of daily living. Then, and I went over this a little bit earlier, the definitional rules for if your condition meets a federal definition are what we call the listings. So do you meet, or are you close enough to the listings to equal them, such that you can have an easier path to being approved? And if not, can you go back to your prior job based on all of your symptoms and all of your health conditions and what those jobs require? And then the last question is, can you transition to any other work in the economy? This can be really challenging. The older you get, when you hit age 50 and age 55 and age 60, it gets a little bit easier to be approved, because Social Security assumes that it's harder for you to transition to other work. But if you're a person under 50, even if you can't go back to the job that you have held your entire life, that is actually not enough to win your case if you didn't meet or equal a listing. You have to be unable to transition to any other work, whether that is seated work, whether that is standing work. If you have any skills that you can bring with you, that can unfortunately count against you. I would point people, I don't know if anyone is a fan of the comedian John Oliver, but he actually recently had a really interesting and enlightening segment on Social Security, and where they talked a little bit about some of the jobs that Social Security uses to judge if someone can transition to work. And they are things that probably haven't existed in the actual economy for decades. And these are things that we fight every day, like nut sorter is one, sorter and handler, like these very functionally simple sounding, but you might not see them, in your community kind of jobs that are very likely being phased out with technological change. So another thing that this new commissioner has pledged to do is really take a close look at that and make sure that people are getting a fair shake as far as what's actually available to them versus what Social Security rules dictate. Moving on a little bit to mental health, which is always, a very big category of people who are having difficulty, working and doing basic activities. If I were to leave a takeaway with anyone who are interested in this topic, there are 4 issues that are called the B criteria that Social Security values above almost any other limitation in terms of deciding if someone can continue to work. And those are your ability to, your memory, your working memory, essentially, your ability to understand, remember, or apply information, interpersonal abilities, ability to interact with others, your ability to concentrate, persist, and maintain pace at work or in any other setting, and then your ability to react to stress, adapt to new situations, manage yourself among the unfamiliar. As rules have tightened in the last couple of decades and recent years, these have become almost indispensable in terms of what someone has to show. So when you think about how do you prove something like this to Social Security, because you unfortunately do have to think in terms of proof. Another reason why it's good to have an attorney on your side when you are in therapy and counseling, talking about these things and making sure they get in the notes. So that way the person looking at your records has an understanding of what you're really facing in your life, because that in itself is not always easy to show, becomes critical in helping people who really, have real impairments, make sure that they are credited and, can get the kind of support that we all need. Yeah, next slide. A little bit more about winning claims in practice. And, if you seek a Social Security attorney and they don't tell you these things, then you may be in the wrong place. But you have to be seeing your doctors regularly. You have to be, as I mentioned, in that mental health context, describing your symptoms. Because, again, we're always thinking in terms of evidence, and that means what's in the medical record. So if there isn't a clear, I'd say, verbose articulation of the challenges that you are facing on a day-to-day as an applicant, it's very, very difficult to get approved. And treating with the right specialists will add extra weight. So, if you have fibromyalgia or other kinds of pain, seeing a rheumatologist, neurologist, pain specialist is very important. Seeing your primary care doctor once every 6 months may not be enough, and very likely will not be enough for Social Security to believe and take seriously the challenges that you are facing in your life as a disability applicant. So again, longitudinal long-term evidence, specialty care, and really being descriptive in terms of what your limitations are is key to any case. So this slide talks a little bit about, the practical process. Before now, I was talking, every claim, when it goes in front of Social Security, they look at it using the analytical tools that I just described. But there are a series of steps that go into a lot of individuals' claims and appeals in order to get approved for benefits. It would be, simple and preferred if it really just took an initial application for someone to win. But a lot of people, unfortunately, will apply the first time and get denied, which does not mean that you should lose hope, give up, or get overly frustrated, even though it's a frustrating experience. There are actually, here I show you 5, there's actually 7 levels of possible appeal that you can do to try to win your case and get benefits going back to the first date that you applied. There are a, not insubstantial amount of people who will win at the initial application. But for a lot of reasons, it's very difficult to be approved right up front, in part because especially if you just recently got injured, you have to go back to that, or sick, you have to go back to that 12-month rule and recognize that in order to win, you have to either have already been disabled for 12 months or have doctors who are telling you and willing to put in the record that you are very likely, almost, unquestionably likely to be impaired for that length of time. Also, there are fewer attorneys who will help you on the front end. So a lot of people who go in, don't know the nuances of winning cases. So you see a lot of denials in the beginning. And by the time you get to the third stage, which is a hearing in front of an administrative law judge, that's actually where most of the cases get reversed. Not all cases do. And then, you can still appeal further to the appeals council and also to federal court, which is where our firm also fights a lot of its cases. And in that process, we're talking, it's a very inefficient system. So we're talking that some people can wait anywhere from like 6 months to a year at the initial stage to 5, 6, 7 years at the district court stage. If you do have to fight for that long, it can take a very, very long time to get approved. The administrative law judge stage, where a lot of people win, can take 2 to 3 years in some cases. So I say that as a number, but if you think about the human cost of that, that's all this time spent when someone is not working, has to rely on their family, has to rely on other benefits, has to dip into their savings. It's a real challenge. So our role is to try to help people win as speedily as possible, while also making them aware of other benefits they can get, while they're waiting. I'll talk a minute about this concept of continuing disability reviews as well. This happens, after you've been approved and after you have been receiving benefits for a period of time. Social Security will come back and look at if you are entitled to ongoing disability for another period of years. They call this CDR. So what will happen is you'll get a letter saying, we're checking if you still meet our criteria for disability. They go through the process again. The big difference here is that if they find you're not disabled, unlike the application stage, you can elect to continue receiving benefits while your case is pending. And in part because of that, where you can get help from attorneys is a little bit different, because on the private side of things, our funding model is based on our ability to work on a contingency basis, which means people aren't getting paid right away. And then part of what the lump sum they get, funds the private attorney industry. On the other side, for the continuing disability reviews, there are a lot of grant-funded and government-funded nonprofits who you don't have to pay directly, and they often can help when the government is trying to take away your benefits. So if you ever are in a situation where you have a CDR, going to legal aid can be very helpful. Yeah. And then a little bit on returning to work, which can be confused with CDRs, because instead of Social Security in the CDR context coming to you and saying, we think you're no longer disabled, in this case, you are actually trying to go back to work. And again, it really matters which program you're in. As I talked about earlier, SSDI and SSI are two very different programs. And the rules for returning to work on SSDI are much more generous. So you have a period, if you decide, that you want to give it a try and see how it goes, you have 9 months out of any of a 5-year period to try to go to work, and you can earn as much as you want without impacting your benefits. So that way, if you try it for 3 months and then get sick again or get hurt again and feel you can't do it, your benefits will continue, not a problem. That's not true for SSI, which we'll get to in a minute. If you do that successfully for 9 months, then your benefits may stop if you work at a high level, but you have what's called a 3-year expedited reinstatement period. So for 3 years, you can quickly get back into the program without going through the much lengthier process at the beginning all over again. If you get through the 3-year period and you're still working, then you're basically out of the program and you need to apply again if you ever get sick or hurt again. SSI, they do not have any of these rules, and if you work for a lengthy period of time above that 1550 limit, you can be, permanently terminated from the program, and any income you receive on any given month can reduce or cancel your monthly benefits. So again, the rules are much harsher, and we unfortunately see, legal aid in particular, a lot of individuals who need help getting rid of or managing what's called an overpayment, where based on work you did or other factors, Social Security decides they paid you too much and they're going to try to collect back the money even if you have very little. So again, there are some really harsh aspects to these programs, which is all the more reason why we have attorneys, ready to talk to you and folks in your community about how to navigate them with minimal problem. All right, and let me pass it over to Paige and take any questions at the end.
All right. Thank you, Mark. Yeah, so one thing that you brought up that I can already see an overlap with what I do in Medicaid and long-term care planning is that you had mentioned an asset limit of $2,000. And I will say right from the beginning, this whole process is very confusing because there's not only numerous different platforms and services available, but like Mark mentioned, within those different programs, you have even more variation. And so, for example, I mean, because even though I've worked in elder law for almost 9 years now, Social Security, disability, and SSI, SSDI, that stuff is so different than the type of work that I do that those sorts of matters I refer to Raymond and Associates because that is what their specialty is. Similar to that is the Medicaid program. So I work with Medicaid a lot of times, but even though there is Medicaid there's different types of Medicaid, there's Medicaid in the community, and then there's Medicaid for long-term care. Medicaid in the community are for individuals who, as it says, you live in the community and you can receive benefits such as like SNAP benefits and monthly income. But where I focus, and because it's so different, I focus in Medicaid for long-term care planning. And again, the requirements, the eligibility, it's all different than Medicaid in the community. So if anyone's looking for a Medicaid in the community, I recommend reaching out to a nonprofit or legal aid organization. Almost always, those are the individuals who can assist with Medicaid in the community if you need an attorney, because they're a lot of times individuals don't have the funds to pay a private attorney. Medicaid for long-term care is a little bit different. And that's what I said. Like I said, that's what I focus on. And just like what Mark was saying, the eligibility requirements are very intense. There's a lot of harsh issues related to Medicaid and Medicaid benefits. And so it's definitely really important to understand the ins and outs before applying for certain things. So like I said, I focus on Medicaid in the community or Medicaid for long-term care. And what that does is cover somebody's care if they need to go into a long-term care facility. The types of long-term care include, there's different caregivers. There are CCRCs, which is a continued care retirement community. There's independent living facilities, assisted living facilities, supportive living facilities, which are essentially a Medicaid covered assisted living facility. And then there's nursing homes, or what's called skilled care facilities. That's going to be our focus today, is the Medicaid for covering nursing homes and supportive living facilities. So for reference, Medicaid for long-term care in Illinois specifically covers care when somebody is in a facility. For the most part, our Medicaid for long-term care does not cover in-home caregiving. There are some states that do have in-home caregivers and that it's covered, but unfortunately in Illinois, the Medicaid long-term care program only focuses on in-resident facilities. Particularly, I'm going to focus now on the expenses of long-term care because they're so expensive, obviously at $285 a day, potentially $320 a day on average. That's obviously pretty pricey. And when somebody is not working for a long time or is living off their retirement benefits, if they were ever able to even save money at all, obviously you can see how quickly you can go through that money if you are paying $285 a day on average for your care. Paying for long-term care, ways to pay for it include private pay, spend down. There's long-term care insurance. There's a partial long-term care insurance, which is a newer topic. And then there's VA benefits and other government benefits. There's also waiver programs. And our focus today is Medicaid for long-term care. So different Medicaid myths and mysteries. Just to clarify, and this is something that I see all of the time, but Medicare is not the same as Medicaid. Medicare is a right after a certain age. It's a health insurance that covers different health expenses, but Medicaid is not a right. It's something that you need to apply for. And the application process can be pretty brutal. There's a lot of times families have done things in the past that they thought they were doing to benefit a loved one or to care for a loved one, but in reality, it in turn jeopardizes their eligibility. Medicaid is a federal program, but like I mentioned earlier, it varies based on state. And in Illinois, particularly, right now, we don't have Medicaid that covers in-home caregiving. So while there's different waiver programs you can apply for, a bulk of the Medicaid for long-term care coverage is focused in Illinois on nursing homes and supportive living facilities. A third misconception is that Medicaid will take all of your money or that the government will take all of your money. That's not true. The government will not take all of your money, but the facilities will. And so the next topics we'll discuss is spend down and Medicaid planning. So the importance of estate planning, and I think this is super relevant to Mark's topic as well. But a lot of times I see people will come in after somebody no longer has capacity to make their own decisions. And if you don't have something like a power of attorney in place, then in order to even be able to do the application process, you may end up in guardianship in order to get the authority to apply for somebody. So it's really important, I think, on all levels, whether you're dealing with SSI, SSDI, or anything else, you should look into estate planning. Particularly powers of attorney for healthcare and property are the main, most basic documents that I would recommend having. Those documents can give your agent the ability to not only do government planning and planning for public benefits, but it can also allow your agent to create different estate planning tools that are useful for your particular situation. One of those being a special needs trust. The revocable living trust is another beneficial tool that, while it does not necessarily house your money and protect it from Medicaid, it can give you the authorities necessary that you need to do asset preservation and assist somebody in the Medicaid process. There's also irrevocable trusts, which is a form of pre-planning, but I'll get more into that. Oh, and I will say that deeds for real property and the TOTI. One thing I've seen pretty often come in is that if there's somebody who's going to need long-term care, or if there's somebody who has a disability or something, a lot of times family members think it's a good idea to transfer away property from that individual, whether jointly or completely out of their name. I always recommend, be very cautious with that, because with Medicaid, at least, there's a 5-year look back period. And so if at any point in time during that 5 years, if there's a transfer of any asset at all, it has to be disclosed. And if it falls under an exempt asset, you're okay. But if it doesn't, then you're looking at potentially having to spend a bunch of money out of pocket to cover your care before Medicaid steps in. So exempt versus non-exempt transfers. And I will say, I saw a question about whether or not you can have these slides. I'm totally fine with sharing these, so we can pass these around if anybody finds it useful. But for Medicaid purposes, there are 2 different types of transfers. There's the allowable transfers and non-allowable transfers. The allowable transfers are under Medicaid policies, allow for certain types of transfers to certain individuals in order to qualify for Medicaid. Whereas non-allowable transfers, if you do make any of those transfers in the 5-year look back period, you are looking at a penalty period as a result of those transfers. So we have this Medicaid bubble, and within Medicaid, you have Medicaid in the community and then Medicaid for long-term care. And then within the Medicaid for long-term care, we have what is called pre-planning and crisis planning. It's called crisis planning because it's an immediate planning that needs to be done, but it's not necessarily a crisis. But I will say that 95% of the cases that come through our office are definitely the crisis planning. The pre-planning is anything that occurs prior to a 5-year look-back period, or any look-back period, depending on the government benefit. But if you do transfers outside of that 5-year look-back period, then it won't impact your benefits at all. Some examples of that would be an irrevocable trust, IRS gifting and transfers of assets. There's different VA benefits and other public benefits that are available to individuals depending on your circumstances. But even those government benefits, even though it's another government program, it may potentially impact Medicaid planning, especially VA benefits, because, for example, while we have a 5-year look-back period, at one point in time, the VA only had a 2-year look-back period. So I would have clients who came in that had been on VA, and the attorney that they worked with or whoever they worked with, they thought they were doing the right thing by making these transfers or to get the individual eligible for VA benefits. But then if that individual needs a longer or a more intense version of care and they can't afford it, then you have to go to Medicaid, and those transfers can potentially impact the Medicaid planning process. There's also what's called a pooled trust. And any transfers in a pooled trust are exempt for purposes of Medicaid, so long as you are under the age of 65. But once you hit age 65, any transfer into a pooled trust will be considered non-exempt for Medicaid purposes, and therefore will create some sort of penalty period. Crisis planning, like I said, that is a way more common than the pre-planning. And this is basically at the time that somebody needs long-term care. So whether it's supportive living facility or a nursing home, the individual has to be in a Medicaid eligible bed. And they need to basically a lot of times spend down their assets in order to get approval for Medicaid. So there's various types of Medicaid spend down strategies that we'll go over listed below. So in 2024, the Medicaid eligibility requirements include being over the age of 65, blind or disabled is currently defined by the SSA or the Client Assessment Unit. You must be a resident of Illinois, and you must be a U.S. citizen or a non-U.S. citizen that falls within certain categories. Your income the income requirement is that it cannot exceed the private pay monthly payment. But since you're looking at around $10,000 a month for a nursing home, particularly, it's pretty easy to not get higher than the $10,000 mark. The asset limit is $17,500, which is actually up from $2,000 as of last 2022. And then, which is interesting because Market brought up there was an asset limit, like I said, to $2,000. So that right there shows the potential complications that these different benefits will and can provide or can cause some people. And then you also must be in a Medicaid approved facility or bed. Spend down and penalties. So spend down is referred to as if you are above this $17,500 limit, you basically have to spend down your money. And a problem that I see very, very often is that when a family has a loved one go into a long-term care facility, the nursing home says, oh, don't worry about that. We'll take care of the Medicaid facility. It's fine. And if what they do is they will submit the Medicaid application despite the number of assets or the amount of assets that the applicant has. And then once you apply for Medicaid, you are locked in. And then they're required to spend any money that they have above the $17,500, previously $2,000. They are required to spend that on medical. So it's basically they're required to spend it on the facility. Now, the reason that that's a problem is because if you get locked into spend down, then you can't do any asset preservation techniques in order to preserve some of the money that could have potentially been used for the applicant's benefit during their lifetime, It could have been gifted to a family member. There's various things that we could have done, but unfortunately, once you submit that application and you're locked into spend down, you can no longer do that because you're required to spend the money on the facility. So if you can see from a facility's point of view, that's obviously pretty useful. But what's not useful is to the family or to the applicant themselves, because not only does that mean that there's no money that can be preserved, but that means there's also no money that can be used if there's a penalty period or if there's some sort of problem with the facility. And at that point, if you're down to $17,500 and you have to all of a sudden pay 4 months of private pay, well, where are you going to come up with the other $23,000? So it's really something to look into and definitely something to consider before anybody does go into a facility or before you sign any contracts. And the penalty period, so that is referring to within the 5-year look back period prior to a Medicaid application. What the state does is they look at every single transaction you've made over those 5 years, including any sales, any opened, closed accounts, that sort of thing. And they basically tally up any of the transfers that they think were non-exempt transfers. So for example, a big one that we see pretty often is cash payments. If you can't explain where your cash went or why all these cash withdrawals occurred, they're going to penalize you. Another common example is gifting. So an example that I've seen pretty often is basically like for Christmas every year, a family would gift their kids one amount and their grandkids another amount. Well, within that 5-year look back period, the state decided that that was not okay. And so what they do is they tally up the total amount of gifts or non-exempt transfers that you've made, and they calculate a penalty period based on that. And the problem is with that is that, again, this is at the point where you have $17,500 or less. So if you apply for Medicaid and then the state denies it or says that you're approved subject to a penalty period, then you have to find somebody, or a family member is then responsible for the payments of that private pay facility for however long that the penalty period is. And that can be a significant amount of money. Otherwise, the facility is able to involuntarily discharge the applicant, even though the facility is the one who applied in the first place. So this is something that if you have a loved one who is going into a skilled care facility or a supportive living facility, it's something to really consider. And I always tell people, do not sign any contracts at the facility. A lot of the facilities will include specific provisions in them that not only prevent you from doing any asset preservation because they want that money, but they can also contractually make your family member or your power of attorney liable for any money that the applicant cannot pay on their behalf. And they get you via the facility contracts. So a few exempt transfers and part of the planning that we do, there's the homestead property, that there's different things you can do with that. There are personal effects. So any personal property of a reasonable value is considered exempt. You are allowed to have a motor vehicle of up to $4,500, unless you have a spouse that's using it, at which point there's no limit on the total of it, the value. And then life insurance, some of the life insurance policies are also exempt, but it's minimal, including a face value of $1,500, or if it's term life insurance or if it's group life insurance. And another exempt asset is the burial spaces and prepaid burial contracts. But while burial spaces are exempt, it's important to note that prepaid burial and cremation contracts are not automatically exempt. So you have to make sure that the forms that you have show that it's a Medicaid exempt asset. And by doing that, you have to name the state as the beneficiary of any money that's not used. I listed here specific provisions that I commonly use for different Medicaid planning topics, whether it's, transfers of real property, vehicles, burial spaces, etc. And I'll include those for reference. Common Medicaid strategies. So again, as long as you do the planning prior to the application, there are a lot of different things that we can do, but it's just really important to not submit that until you are at the eligibility. Otherwise, again, you're going to get locked into spend down. But different Medicaid strategies that we have out there, there's ones related to community spouses. So for example, if one spouse has to go into a facility and the other spouse is still living in the home in the community, there are different rules and regulations that we can use to preserve assets for the community spouse, because obviously we can't have that community spouse go broke and not be able to pay for themselves. People with disabilities. So any transfer to an individual with a disability, a child with a disability, is considered exempt. Medicaid's, the state's reasoning behind that is basically that they see it as, well, if this individual gets money from a family member, then they are going to be able to live on their own for longer and the state will not have to cover it. So that's why all of those transfers are exempt. There's also rules for child caregivers. So even though Medicaid does not cover child caregiving or caregiving in the community, there are different things that we can do as pre-planning. One of them that's pretty common is what's called a child caregiver agreement. And basically, when a child is in charge of providing care for their loved one, we can, as long as there's a formal written agreement, we can have the applicant pay that child on behalf in order, as like a payment for caregiving. It's very important, though, to make sure to have that contract or that agreement in place. Otherwise, the state will claim that any money that was given to that child was not for a service, but was considered a gift, and therefore they will penalize you for it. There's things called Medicaid compliant annuities. That's something I also use all of the time, and it basically allows us to gift a certain amount of assets. So let's say somebody comes in and they just went to a long-term care facility and they have $400,000 left in total assets, but they also have a community spouse. So the community spouse is allowed a certain amount, which we will get into, but then obviously it leaves a big chunk of money that is available that we need to either spend down or gift at some point in order to get on Medicaid. But in order to gift that money, you have to be prepared for a penalty period. So basically, we would take half of the money, turn it into an annuity stream, an income stream to cover the cost of the penalty for however long the penalty lasts based on the gift amount. We work with a company that specializes in Medicaid compliant annuities. And the reason that it's allowable under Medicaid policies is because you have to name the state of Illinois as the beneficiary of any of the funds that are left if somebody passed away before the gifting had been completed. There's also irrevocable trusts. Like I said, that's pre-planning. A lot of times, because any transfer into an irrevocable trust is basically transferring your asset away from you, and therefore it's not available. So if you do an irrevocable trust or some type of irrevocable trust, it's really important to calculate out the money and to make sure that if somebody were to need long-term care tomorrow, that you have enough available money to pay for that care over the next 5 years. Otherwise, you're going to be penalized for the value that was transferred into that irrevocable trust. There's home purchases and repairs. So in Illinois, your community spouse is allowed to have a home that's up to, the figures just changed, but it's around $688,000 for a house. So that's a significant price for a house. And I know the market's not great right now, but even considering most people don't have houses worth $688,000. So one of the ways I've used in the past is basically to use some of your liquid cash to buy a bigger house and then get you eligible in money or get your assets down to the $17,500 and have the bigger house. And if the community spouse then wanted to sell it or something after the Medicaid process is over and downsize, then you can at least use the portion, the difference in those prices to have, in addition to the assets that you're able to keep as the community spouse. There's also the purchase of other assets. So like I mentioned earlier, there's prepaid cremation and burial plans that can be taken care of. You're allowed to have a vehicle. and you're allowed to make other different like small purchases, whether it's to improve your home, to car repairs, all sorts of different things. Community spouses. So if somebody had to go into a long-term care facility and needed Medicaid, there are rules that protect the community spouse, because again, $17,500 is not enough for anybody to live on these days, let alone somebody who is living on their own and retired. So the income asset limits as of 2024 well, 2022 is when it changed, but as of 2024 now, the limit is $129,084. So basically, in order for the applicant to be approved for Medicaid, they can only have $17,500 and their spouse can have up to $129,084. They are also entitled to income of up to $3,853.50. So what that means is if the community spouse's Social Security or pension total income per month is less than that amount, what we're able to do is gift some of the applicant's monthly income to the community spouse each month up to that amount. And the homestead is $688,000. Spousal refusal is another option, but I will say that NALA right now, we have a legislative committee that works with different lobbyists to get different laws and policies passed to benefit our clients. And one of the ones that we are seeing as a major issue right now is the spousal refusal, because the state has decided to come back and start coming after people who have previously applied the spousal refusal, claiming that they are now entitled to that money. So if that's something you're looking into, I highly recommend working with somebody who is very has a good understanding of the Medicaid process, because it's not only it's already a risk, but if you're going to do it, make sure that you do it the right way. So Medicaid application, common complications and concerns that I see. So loans to family members or gifts to family members is a huge problem across the Medicaid planning world. It happens all of the time. A lot of times it's not even intentional, to gift. It may sometimes be a reimbursement for something, but unless it's documented properly, the state will automatically assume that it was a gift. So any loans to or from family members, if you do loan any money to an individual, make sure that there's a written promissory note or loan agreement so that it's clear that it's a loan and not a gift. Other issues are prior transfers and commingled assets. So again, when family members start taking care of an older adult or an older family member who later needs long-term care, a lot of times they haven't been involved in the financials for a long time. They don't know what's going on. They don't know where anything is, and they basically will have to spot money to the family member. If that's something that happens, make sure again that you document it as a loan, because there are ways that we can get that money reimbursed. There's the unknown history, family not previously involved. There's shady family members and financial abuse. So unfortunately, it's not uncommon for me to see a situation where a family member has just stepped in to help a loved one, and we start looking through the finances and realize, oh man, there's a whole lot of transfers here and a whole lot of missing money. What's going on? So that's a whole area that needs to be explained in detail. Otherwise, again, all of these gifts, if not otherwise clarified, are going to be assumed as gifts for the purpose of applying for Medicaid. ABE Online is the system that we now use since COVID for the most part to submit the applications. I will say that ABE is constantly changing, and it just went through a very recent update within the last month or so, and we're not even able to use it right now. So the complications there are, again, the state doesn't even necessarily care that you can't apply because of their own system. So just make sure to leave plenty of time to understand that it's not the easiest process and it's not the most practical process either. The biggest issue that I see is the different facilities applying for families. So like I mentioned, it's not uncommon for facilities to do this. It's basically submit an application before somebody hits the eligibility marks, and then they're required to spend that money down. A lot of times what also happens is they don't take the application seriously, and they don't look into the 5-year look back period. So they don't have any idea what has happened prior to the application. So if there were gifts to family members, if there were assets sold for less than fair market value, and those weren't taken care of ahead of time, then what's going to happen is whether or not the application gets approved, there's somebody that's still going to be responsible for paying privately roughly $10,000 a month until Medicaid is covered. So that is all I have. It's right at 7. Sorry that, and just know that Medicaid and SSDI, SSI, they're very, very complicated processes that I think we could both have talked on for another hour. So if you do have any additional questions or concerns, our information is here. And I think that we're both more than happy to be available for any questions.
Great. Thank you so much. That is a ton of information to cover, and you did a wonderful job, and I definitely learned a lot. We do have a few questions that I will now relay from some of our participants. One of them is, what difference does a mental versus a physical condition make in terms of the likelihood of qualifying for disability benefits? I know, Mark, you talked about this a little bit in terms of the qualifying factors. In practice, is it more difficult if you have, PTSD, depression, some other sort of mental condition that's preventing you from working versus, say, something like black lung, where there's X-ray scans that show, the physical damage?
Yeah, I mean, it's a good question, and it's hard to give a broad brush answer. I mean, one thing I'll remind is Social Security is required to not look just at your physical and not look just at your mental health, but to look at the combined impact of everything. It's why, both for your health reasons, but also for winning cases reasons, it's so important to pursue care in all avenues. You want to both be seeing your primary care and physical health specialists, and also, if you need it and if you feel it can help you, seeking out counseling, seeking out psychiatric treatment. So that way, the limitations on both sides of the coin are going to show up in your records, and show, the true limitations you're experiencing in the record, such that it's easier to get approved. It really, I mean, if to the extent the question is really about like one versus the other, they're different. I mean, I would say you always want to be talking about any limitation you have to any care provider. It's particularly important in the mental health context, just because our physical health treatment in so many ways is more precise, you might say. And I don't even know if I want to say more advanced. You probably could say that, but just in the sense of like measurements and testing, more often they're looking at particular measurements that, just have to do with what test you underwent, or what surgery you had, or how long you were in the hospital. Whereas mental health, it could also be applicable there, but it's often coming down to case notes from conversations with therapists. So it's very important in that context to talk about if you're having memory challenges, how that impacts you day to day. If you're having, interpersonal challenges, what you experience that like, and why it makes it hard to do daily activities and work. So I hope that answers your question with some complexity.
Great, thank you. Does Social Security ask about an applicant's arrest or criminal background, and take that into consideration?
Yeah, I saw that question, and I share some of the frustration. I mean, they can ask about it. It's not going to always impact your case, even if you do have a record. There are some limited circumstances, usually with like active warrants or active felony charges, that could impact your case. But if you have a record that is, over and done with, you should be fine.
Great. What other benefits are available while someone is waiting for approval of disability benefits?
Oh, that's a great question. And Paige, jump in too if you're aware of any. I mean, when I was prior to working at Rabin and Associates, and we continue to do this here, but there's a lot of wonderful nonprofits in the community that we try to help people understand the wide range. So you could start with, like, again, unemployment insurance. If you, I mean, that what you have to remember, and Paige really touched on this, like every program has different rules, and every program is designed for different purpose. So unemployment insurance is something to always keep in mind, but you have to be able to go back to work to some extent, even if it's lesser, and be looking for work. SNAP benefits are available based on income. There are cash benefits called AABD and TANF, that you can get based on your family situation and how much money you earn and have. There's a program called the Medicare Savings Program, which is also income based, and you have to have Medicare, but it can save you the cost of premiums and certain copays. There are subsidies for both water and energy charges. There's, in some cases, subsidies for rent. There used to be a subsidy for wireless in the federal level, but that went away, unfortunately. So sometimes these benefits are changing. If you live in Chicago, it's a good to keep your eye on what the city does, because they often have new cash programs specifically available. Let's say if you're homeless, or if you are a domestic worker, or if you suffer domestic violence, that kind of come in and out. Rental assistance is back. There have been mortgage assistance programs. So I'm kind of going through, a lot of these different programs. I like to use the term scattered safety net. There's a lot out there. So I would recommend talk to people and like get in touch with providers, law firms like Paige and I, and legal aid providers. Mm-hmm. And we can guide you. But you unfortunately have to go through like a lot of different application processes and really know what you're looking for to access the full benefit.
Yeah, you've mentioned, obviously you and Paige are great resources, and there are obviously elder care law firms and disability law firms out there. Are there other organizations that you can particularly recommend where people can educate themselves on these topics, where they can receive help with applying for these benefits? That, if they can't maybe necessarily afford, your very fine legal services.
I can start out by saying that there are a few nonprofit or legal aid places that do handle Medicaid in the community. I also know that for the different DHS departments, there's the different hubs and social workers that'll help with the applications. But and there's a whole bunch of information online. So I cited a bunch of the policy manual in the slides that we can share. But for the most part, there's no one place to talk to somebody about all of this stuff, just because it is so complex, depending on what benefit you're looking for, that there's people who only focus specifically on those benefits. So doing your own research in general online is a good idea. I can provide a list. I can follow up with some legal aid organizations that I refer people to, and the different, VA benefit hubs and all of that as well. But I don't know, Mark, do you have any additional references or?
Yeah, I mean, I think you're largely right that it's unfortunately, it's like there's so much specializing that you have to kind of go from place to place. If you're really in a pinch, I would say 211. Because it's a sort of a newly reinvigorated database of different resources that, they may not be the ones themselves to help you with any particular benefit, but they are supposed to be keeping like the full record of like what's out there in the community. So that could be a place to start.
Great. Yeah, we do have, just side note, Evanston Public Library does have a list that I've put in the chat for everybody. Yes. Of low cost and free legal resources. So you're welcome to check that out. And of course, Mark and Paige, if there's anything missing, please let me know, because I love to keep it as up to date and as helpful as possible. So anything else you have to suggest would be wonderful. We have a couple of questions about long-term care facilities. One is, are you able to work if you are in a long-term care facility and keep your earnings, or does that all go to, is that not possible under, say, Medicaid or Medicare?
It is possible. I just don't know how beneficial it would be, because basically if you do have any income, and I see this a lot of times with like rental properties, for the most part, all it does is basically lower the amount that the state pays and then because your income covers that portion. So you can continue working. And I think that if I knew more about the specific situation, there was probably ways that we could work around it. But from a general level, I would say I don't know if it would be beneficial for you to have that income, because basically what happens is when you there's a private pay rate for the facility. So let's say that's like $10,000. And then there's the rate that Medicaid pays. And they usually negotiate that to, let's say, $6,000. So then what happens is they take the applicant's monthly income and they subtract it from their negotiated rate, and then they pay the facility that amount each month. So when I say that your income just is supplementing the facility, it just means that you pay more to the facility and Medicaid pays less. So unless there's certain things that are set up, different accounts, there's special needs trust, there's other things available out there that you can potentially work with. But I would say on general question or general answer is it worth it to work? I don't know. Can you? Yes. And so that would be something to kind of look at more on a case to case basis. But unfortunately, yeah, that's what would happen with the money.
And then also, if there is abuse within a long-term care facility, what sort of categories of things are considered abuse, and what kind of proof do you need? Who do you seek help from if there are concerns of abuse in a long-term care facility?
So there are a lot of different resources available. That's something that I would probably have to send a list more. But again, there's different private organizations and also nonprofit organizations that can assist with like the elder abuse situation, whether it's looking more into a situation or filing a lawsuit or something. But I can send some resources that I have for that. But a lot of times you're either dealing with somebody like the OIG who can investigate something like that, or a private attorney who is going to bring a lawsuit. But even, those lawsuits are time consuming and extremely expensive and very stressful. So I would say to talk with somebody who specializes in elder abuse or to look at the different programs in the community that they have people available to like look more into the facility. But if you do think that there's something going on, I would definitely report it, and I can follow up with some additional resources that I've provided in the past. But I also I send a lot of my potential elder abuse situations to Levin and Bercanti. That's a big one in the Chicagoland area, but there's a bunch of smaller firms that I work with as well that can handle that. So if that is something, I'd be happy to talk with you about or send you to a local organization who can look more into it as well.
And just to clarify, that applies to both elder abuse and to abuse of someone with another disability who's not necessarily elderly within a facility too.
Absolutely. Okay. Absolutely.
All right. And then I think finally we have a question about if you're struggling with mental health, but have hopes of getting better, is there help for going to school? Is that maybe a better route? How does that play in?
For the benefit?
In terms of benefits, getting benefits, are you able to go to school? Is there help for going to school? Is that an avenue that people can pursue?
Mark, do you want to take that?
Yeah, there's certainly loans out there and some subsidies that I'm personally not as familiar with. I think it in part depends kind of what school you'd be looking at, and whether maybe there's like help tied to that specific type of program or that school itself, more than any general program, at least that I've seen.
And then we just have a clarifying question on for individuals heard conflicting info. SSDI, is it open to individuals over 65 and permanently disabled individuals, or only over 65?
So it has a different name. Once you hit 65, the SSDI is generally called retirement, but for all practical purposes, I mean, you don't have to go through the same medical assessment, but it's like the same. You're pulling from the same earnings. It operates the same way. And then there's SSI, which is both below 65 for medical and then above 65 for age. I will note, I see there's a Medicare question in the chat. I don't want to let pass either.
Yes, go ahead, please.
Yeah, so Medicare eligibility below 65. This again depends on a couple of things. If you are medically disabled and found disabled by Social Security, there's a longer waiting period from the time you first start getting SSDI payments, which is 2 years, before you can then qualify for Medicare. But the catch there is you have to have enough work credits, similar to SSDI, enough earnings to get that below 65. At 65, you also, just get Medicare. Everyone gets it with, pursuant to certain immigration requirements. But what happens for folks who are, let's say, on SSI, they may be told that, once you hit 65, you can qualify, but it's too expensive for you because you don't have enough earnings to pay off the premiums. There's a better way to phrase that. In Illinois, there's a program, this is one of the lesser known programs, called the Medicare Savings Program, which will actually pay off your premiums for you. And there's you don't have to remember all this now if this is what your question is about. But it's important to remember that folks who are transitioning from SSI to post 65 retirement can actually still get Medicare in many cases, and a lot of Social Security staff have shown that they are not as familiar with this as they should be. But they have to go through this process where they apply for conditional Medicare and then go get the Medicare Savings Program, which then pays their premiums and avoids them having to pay like most of what their benefit would be to Medicare, and thus leading to someone saying, oh, you can't afford it. So it is more accessible for both people who do and don't have earnings requirements at 65 than a lot of people make it out to be. But if you're on SSI before 65, there's usually, except unless you have certain health conditions, you're unable to get it. Kidney failure is one where you can. I hope I answered that question. It talks about implications for the Medicare benefit too, and if there's more to that, I'm happy to answer.
Sure. Well, thank you very much for. Oh, go ahead, Paige.
I just want to say really quickly, in case that we didn't make this point enough. One thing that I highly recommend, if for anybody who is on a disability or SSDI, SSI, or any sort of public benefits, that to talk with your family members who you may get an inheritance from or something, because we can very easily set up what's called a third-party special needs trust. So if people are, you are going to receive money from an inheritance or something, rather than receiving that money outright and therefore impacting your benefits, we can avoid that and have it go into a trust for your benefit that can pay for things like school and other different benefits, other, pleasures, like life things that would not otherwise be covered by the benefits. And so just that's something to keep in mind. And also the first party trust, which is basically your money that you can put into a trust, which is an example is like a pooled trust. So that's ways that you can cover things like school costs and related matters if without impacting benefits. So I just wanted to mention that.
Great. Well, thank you so much to both of you for a wonderful presentation, for staying over to answer questions. There was one more about whether there are follow-up seminars on these topics. Just wanted to remind everyone who is registered tonight that you will get a copy of the recording once that is posted on our YouTube page at the email address you registered with. I will also send out the slides once I get them from our presenters here tonight. Evanston Public Library does have a twice a month Medicare program that explains some of the ins and outs of Medicare. You can contact Evanston Public Library for more information about the dates and signing up for that. I know Chicago Public Library also has similar programming, so check their website or give them a call for more information on their programming. If you are in Evanston, the Levy Senior Center also does programming and provides assistance for people who are applying for Medicare, Medicaid, similar benefits. So I hope that answers that question in part. We are always here at the libraries, both libraries. If you have questions about this type of programming, we will help you track down people who can provide more information for you. So thank you everybody for coming out tonight. Again, thank you to our presenters so much. And I look forward to our next session in November.
Thanks for having us.
Thank you.
Thank you
so much. Have a good night.
You too.